So, what did the Obergefell court hold? And here's the importance of the holding. You've probably been to marriages where the minister gave up a little homily for maybe 5 or 6 minutes, said, by the power vested in me, you're married. You've been to some places where they maybe went through all of covenantal theology from the beginning of the covenant with Adam, and an hour and a half later, they got to the marital covenant. But at the bottom line, they still had a holding, right? By the power vested in me, you're married. All that stuff from the 3 minutes to the 3 hours is all nice stuff, but you have to look at the holding. And so what did the Supreme Court hold? Well, they held, and this is a quote, the state laws are held invalid to the extent they exclude same-sex couples from civil marriage on the same terms and conditions as opposite-sex couples. They said the laws are held invalid. Now, I saw a couple of you, not over the internet, I can't see you, I promise, but it kind of like, the laws are invalid to the extent. What does that mean? Well, let me just put for you what our law says. Our law says this, quote, no county clerk or deputy clerk shall issue a marriage license until the applicants make an application in writing stating the names, addresses, ages, addresses, social security numbers of both the proposed male and female contracting parties. Now, I don't know who's listening on the internet, but I know most of the folks in here, and apart from me and from Zach, I don't think there are any lawyers in the room. So you're at a great handicap to read that statute and say, does that seem to exclude same-sex couples from marriage because it says there has to be a male and a female? Now, I know that's a tough thing. Put on your thinking caps, and you would probably say, yeah, when Bob and Fred, I don't know which one's going to be the female. When Susie and Sally show up, I'm not sure which one's going to be the male. That would mean, therefore, it would appear that the law is invalid because it excludes same-sex couples. Brilliant. You just graduated from law school ahead of most lawyers in the country. I mean, when after all, lawyers don't know what the word is, it's probably hard to figure out some of this other stuff. But look at the contradiction of what the court said. The court has a second holding, and here's what they said a few paragraphs later. They said, this court in this decision holds same-sex couples may exercise the fundamental right to marry in all states. Now, they just said this, right? We hold the laws are invalid. We hold that you can get married under the law. That leaves us with two questions. How do you exercise a right to marry, which was the second holding, under a law that under the first holding has been held invalid? How do you get a valid marriage license if the law is invalid? And then there's this other interesting thing. I was talking with Zach today, who's a lawyer, and so sometimes we have lawyery discussions. And he said he was talking with some of his other law friends about the statement that the law is held invalid to an extent. How is a law invalid to an extent? Can a law be more or less constitutional? Now, I know that all of you in this room have either had a mother or you are a mother. And I would like to ask the women, have you ever known a woman who was pregnant to an extent? More or less pregnant? No. What's very interesting is Chief Justice John Marshall, who wrote the Marbury versus Madison decision that gave us this concept of the judiciary reviewing laws to determine their constitutionality. He said, a measure may be more or less wise, depending on the circumstances, but it can never be more or less constitutional. And you know where I found that statement was I found that statement in the majority opinion in a case from 2011 called NFIB versus Sebelius. That's the case in which the Supreme Court said that Congress could not threaten states by withholding money if they did not expand Medicaid. That was an attempt to commandeer a state government to dictate to them what they should do, and it was in violation of the principles of federalism. And it was in that case that I read that quote, and in that opinion, it was joined by Justice Kagan and Breyer, who are two of the judges who wrote that the law is invalid to an extent. A law can't be more or less constitutional, but it can be constitutional to an extent. Do you see some of the irrationality and illogic that we're finding in our court? That begins to happen when you try to reach a result and then figure out how to get back to the answer.